Jesus. Alright, good afternoon everybody. Thank you for joining us on today's session with Accent Nominees. This is your business with Accent Nominees. My name is Daniel Olukayode Adeyemo, and today I'm bringing you a very important topic at this time, which is trademark. So in full, what next after business registration and trademark registration? This is more like a continuation from where we stopped the last time. So if you've been following us, you know that we actually looked at trademark registration many weeks ago. And if you're watching this and you've not actually seen it, it will be our advice that you actually go back and check it so that you're able to understand what we'll be talking about today. Because today is more or less like a continuation, from where we stopped the last time. So, like I said, the times we are currently is what necessitated us to actually, look into this, because we discovered that we didn't actually cover certain key areas that we should have covered in previous weeks ago. So today we'll be looking at, I'll be taking you through major 3 subheadings: exploitation of trademarks, ways of enforcing trademarks, and possible defenses for defendants, that have been accused of trademark infringement. So starting with exploitation of trademarks. Now it's very important for you to note that, for you to even claim to have the right to exercise certain things around your trademark, you must have registered it, and such registration must be valid. That is very necessary. So where this is not in place, you don't have any rights around your trademark, around whatever trademark you use. Now there are certain rights which we'll be looking at very shortly. One is the right to permit, one is permitted use. So what this one is saying is that you grant someone the right to actually use your trademark for a particular product. But what happens there is that there's usually an agreement between you and that person. In other words, to further buttress it, there's an agreement between you people, and then the scope of that use is restricted based on the agreement between you. So in a situation where the person goes ahead to go outside of that scope, there will be an issue, right? So in other words, now you're granting the person the right to use your trademark for certain goods, certain services, but on a restricted scope based on the agreement you already have with the person. So that is how that one works. So you don't go outside, the ambit of the agreement you already have. So, and another thing to note here is that the trademark is still subject to the control of the proprietor, that is the owner of the trademark. So it is still subject to that person's right, and of course to the scrutiny of the registrar. So it's very important you note that. Another right you have if you go take a step further, take a step of registering your trademark, is the ability to assign that trademark. And you know what assignment is? You're divesting yourself of all the rights you have on that trademark. You're giving it to another person. Unlike granting permitted use to another person. That person will use it for a while based on the agreement for limited product, and then the person will return the right back to you, right? But for this one, you are giving the whole thing to the person. That's why it's called an assignment. So you are assigning your right to this person, is called the assignee. The person assigning is called the assigner. So you're giving all of those rights to the person to actually exercise, the right. And of course, what will happen is that the person will be able to use the product, use the mark on varieties of products and services. And one very important thing here is that when you assign, it's not for the assignee to take it back to the registrar to have it registered. Right, so the registrar has to register that assignment. Same for the permitted use. I didn't mention it. Once you grant the right to use a product for a for a limited scope of product or for a limited time, depending on the agreement, that person you're giving the right has to go back to the registrar, of the trademark to actually register that permitted use. Is very, very important. Now another one is franchise. So franchise is more expansive in its scope. Why do I say this? Unlike permitted use, which is for the person being granted is still subject to the control of the proprietor, and as anywhere you just only give your trademark to the person. For franchise, you're actually relinquishing all of your intellectual property rights. And why is it this? I will give a scenario. Now you have a company. Mr. A wants a company in Nigeria, right? And then he now seeks to replicate it in a different place, let's say in Kenya, right? Of course, you enter into an agreement, a franchise agreement, reflecting all of those things, and then the modus operandi of that business in Nigeria will be replicated in that other nation, in that country, right? So the logo, the trademark, the patents were applicable, the what do you call it? The trade secrets, the industrial designs, all of this all of this intellectual property rights, they'll be replicated in another country. A very good example of this is Low Accent as a brand. Here we have Low Accent in Ikeja, Lagos, Nigeria, right? But also we have another one in Kenya. And if you look at it, if you compare the two companies, you see that the two firms, you see that we use the same logo, the same color, the same this, the same that. The mode of operating, the things we do, they do it there also. That is how franchise works. So now what this is, like I said, it's expansive in its scope, because we're not just looking at trademarks. We are giving them trademarks. We're also giving them patents. We're allowing them to use the patent. We're allowing them to use the trade secrets, industrial design, the copyright, all of those things. They have access to it. So this is why it is expansive in its scope. I hope you understand this. All right. So now, these three channels of allowing people outsiders to come and use your rights, in your trademarks or intellectual property generally. Now, these are the only means through which another person can come and use your intellectual property rights, specifically your trademark being the subject of discussion here, right? So, anybody that goes outside of this, that circumvents any of this to actually just go and make use of your trademark for his product or service, that person is said to have infringed on your trademark. Right, on your intellectual property right, which is a trademark, being the one we're talking about currently. So the person is said to have actually infringed on your rights. So it's very important to know that. And now, when there has been an infringement, what are the ways of enforcing your trademarks? So one is to reach out to your lawyer, of course, to pass on a cease and desist letter. I mentioned it in the last one we had, if you still remember. The cease and desist letter, which will be passed on to that brand that's actually making use of your trademark without your permission. So basically, the whole essence of this is to warn the person to put his brand or a brand in order, to put an end to whatever it is they're doing with the trademark. Because you understand that, like we mentioned also many weeks ago on trademark, is that the goodwill of a business attaches to it. It's a mark that, or a word or whatever that someone sees and can say, oh, this is this brand. Peradventure the person that's actually unjustly using your trademark goes ahead to provide services that are substandard to yours, being the real owner of that trademark, or the product the person is churning out, is less, is inferior to the one you're doing. It can impact on your business because people will know that you are not the same person. So this is where it comes in. This is where you have the right to actually, once you've registered your trademark, to do everything to protect it from being unlawfully used. So like I said, the cease and desist letter is for them to say, you know what, please stop this, stop all of this thing you're doing. It's negatively impacting on the goodwill of my business. So that is why this one is necessary. Another one is the notice of opposition. So if you also remember from the last one we did, I took you through some of the stages of registering your trademark, and we got to a particular stage where we're talking about how that there's this stage where the trademark you're trying to register is published. I think you remember that, where it is published in the trademark journal. So now, where it is published, we also remember that I actually said something about the 2 months gap for people to come and send in their opposition. So these people that are sending their opposition are people that have actually registered their own trademark. So when they see that the trademark you're trying to register is similar to their own, this is for them to actually now send in their own opposition that, what, this person cannot register this, it's similar to the one I already operate with. And then it's now for the person trying to register to actually reply to that opposition. It's very important to note this. So, in other words, this notice of opposition is useful when the other person is trying to register a trademark that is similar to your own. So this is where that one works. Another one is institute an action. And aside from those other two, there are options. Take note that all of these things are options. They don't go together. You can pick any one of them to go with, depending on your situation. Now, you institute an action. That's one thing you can do. And how you go about this, of course, when you're trying to institute an action, you are going to provide proof of the fact that, this person is trying to infringe on my trademark. This person is playing with my mark and all of those things, that the person should drop it and all of those things. So you're trying to institute a civil action against that person. So that is how that one works. And of course, like I said, you need to provide proof. Yes. And then apart from proof, there are remedies that are available to you. One of it is the need to actually, you will be asking the court for damages, right? You'll be asking the court for damages. That is that anyways. Then you can also ask for injunction that the person be restricted from carrying out, that said act. That's an act of using your trademark for the business. So you can also request that the court orders that. Another one is let me see. Another one is, yes, asking the court to order that person, that other party, to account for the profit they've made from infringing on your copyright, on your trademark. Sorry, something about this thing is you are a business on your own. Let's say Mr. A runs a business, and he has, over the years, he has, his reputation has grown. And then you, outside from nowhere, you just pick the market and attach your product, and people start buying from you because you know what, they feel like, this is the same person, and your business is reputable. Now it's for you on this basis to say, you know what, my lord, this business, right, is a reputable one, and there's no way within this period of time that this person has been infringing on my trademark, we would have made a certain amount of profit. So now it's for you to now seek the court that, you know what, please order him to account for all the profit he has made and let him pay all the profit to me. So that is another relief you can seek the court for under this. Another now is formal application for the cancellation of a registered trademark. So here the trademark has been registered, right, and then you are seeking the court for a formal cancellation of that trademark. So for I don't know if this is how it works, but then let's say, for instance, the person, remember the one we mentioned before, which is the notice of opposition, right? So let's say you didn't even know that there was any publication in a journal, and the person that's going to register the business, the trademark, and it's for you to seek for cancellation, apply for cancellation. And this cancellation, you can apply to the Federal High Court or the Registrar of the Trademark. So it's very important you take note of this. Now let's move on to defenses. Okay, now you that they've been accused that, oh, you're using my trademark and all those things. What are the possible defenses that are available to you? So what are the possible defenses or defenses that are available to you? One is validity of the registration. What this one is saying that you, as a business owner that has been accused of using someone's trademark, you can, defend your position by saying, you know what, this trademark was not validly registered by the proprietor or the plaintiff in question, right? It wasn't validly registered, and you can bring your proof and present all of those things, and that's how that one works. And though, for example, one basis upon which this can be raised is where there's been fraud. You can say the person obtained the registration by fraud, right? So that one may avail you depending on the situation. Now another is no likelihood of deception. So this one is such that you as a defendant, you that has been accused, you are saying, you know what, this mark you're even talking about is not similar to the one I'm using. Look at it. There's nobody in there, right? A random, like an average man will see this and know that there's a difference between this. So there cannot be any form of deception. It's clear the difference between these two marks are very clear. So that is another one. So another one now is the right to independent use, and this one would usually come under three instances. One, which is that the defendant has validly registered the mark through those similar to the plaintiff's. So what this one is saying is that, yes, the plaintiff has come that you're using a similar mark as mine, but the person is now saying that this same mark you're talking about, I've registered it validly, like I registered it without any form of fraud or anything, validly. So this is an instance. Another one is the defendant or its predecessor has continually used the mark from a date previous to the use and registration of the mark by the plaintiff. Thus, the defendant is said to have a vested right in the trademark, and the continuous use of same cannot be interrupted. So what this one is saying in essence is that, you that are bringing the action, the plaintiff bringing the action, and then you as the defendant being accused, you as the defendant can actually state that, prior to this plaintiff registering this trademark, we've been using this trademark, or our predecessor, they've been using this trademark years before. So in a situation like this, your use of that trademark cannot be interrupted because most people already know you with the trademark, most likely, right? So your use of that trademark cannot be interrupted. That is what this one states. So another one now is consent. Finally, consent. Of course, obviously, remember at the beginning we talked about permitted use, right? Which is one of the rights. As long as you as a proprietor, you've registered that trademark, you can validly give it out, to an outsider to actually use that trademark, for a limited scope, depending on the agreement you have with that person. So don't let me go too far. Now, by consent, we are saying that person has actually given you consent to use it. So ordinarily, when the person gives you consent, it doesn't make sense that a person will be bringing an action against you. You can validly say that, this person actually gave me consent to use this trademark. Right. So the only time there will be an issue in a situation like this is when that proprietor or the plaintiff is able to prove that, within this scope, this person has gone outside of the scope of the agreement with which we agreed. And of course, you need to provide the agreement to see that, oh, this is what we agreed, and look at what the person is doing. So in this situation, you can actually validly, push away any form of accusation from a plaintiff or a proprietor that you've actually trespassed or you've actually infringed on their trademark. So in general, that will be all for today. We've looked at exploitation, being one of the, being something you're entitled to as a proprietor, where you've registered your mark validly. It has to be valid, very important, it has to be valid. And we moved from there, we looked at ways of enforcing, your trademark, where anybody has gone outside of these means of exploiting, that is the permitted use, the assignment and the franchise, the person now double-crossed and decided to, go about it a different way by using your mark without your consent. Right, so we looked at ways through which you can actually enforce your trademark. Then we'll move from there to look at, to even come behind the person who has been accused. What are the possible defenses available to you? So we've looked at all of this. I hope you're able to understand all of these things, and I hope that you're able to put all of these things into practice. Don't get yourself in the case of infringement and all this. Save yourself of distress, and I wish you all the best in your business venture. Thank you for listening. I'm Daniel Olukayode Adeyemo.